The relevant section under BNSS, that is Bharatiya Nagarik Suraksha Sanhita, when can criminal trial be transferred from one state under section 406 of the CrPC, equivalent section under BNSS. When can the cases be transferred from one state to another? Before we understand this judgment, it is very important to, Supreme Court stated that an order of the transfer of the trial cannot be passed as a matter of routine. These 5 important points are very, very important with respect to, my dear friends, this is a landmark judgment with respect to section 406 of the CrPC. My dear friends, Supreme Court has come out with a landmark judgment with respect to section 406 of the CrPC. The relevant section under BNSS, that is Bharatiya Nagarik Suraksha Sanhita, is section 447. In this landmark judgment, the pertinent question of law that is answered is, when can criminal trial be transferred from one state under section 406 of the CrPC, equivalent section under BNSS is 447. My dear friends, this question is explained by the Supreme Court in a detailed manner. Sendur Agro and Oil Industries Pranav Prakash versus Kotak Mahindra Bank Limited 1503 TPCRL number 608 2024 and others. My dear friends, this is a judgment which will provide you a guideline. When can the trial be transferred, or rather when can the cases be transferred from one state to another? Before we understand this judgment, it is very important to read section 447 in Bharatiya Nagarik Suraksha Sanhita 2023. My dear friends, 447, equivalent provision was 406 of the CrPC. Section 447, the power of High Court to transfer cases and appeals. In that subsection 1 clearly provides, I read the exact provision of section 447 subsection 1. Whenever it is made to appear to the High Court, A, that a fair and impartial inquiry or trial cannot be had in any criminal court subordinate thereto, or B, that some question of law of unusual difficulty is likely to arise, or C, that an order under this section is required by any provision of this Sanhita, that is this criminal procedure code, or will tend to be general convenience of the parties or witness, or is expedient for the ends of justice. It may, my dear friends, the wording used here is may, that means discretionary power of the court. It is not shall, very important word, because it's not mandatory for the court to transfer the case from one state to another just because you made an application. The wording used here is may. Accordingly, my dear friends, that any offence be inquired into or tried by any court not qualified under section 197 to 205, both inclusive, but in other respects competent to inquire into or try such offence, that any particular case or appeal or class of cases or appeals be transferred from a criminal court subordinate to its authority to any other such criminal court of equal or superior jurisdiction, that any particular case be committed for trial to a court of session, or that any particular case or appeal be transferred to or tried before itself. Then in all these cases, the case can be transferred from one state to another state. It is a pure discretionary power of the constitutional court, that is the High Court. Accordingly, my dear friend, the students of law, all the law students should understand, because many of the law students watch this clarification or would like to know about the clarification provided or observation provided as part of the Supreme Court judgment, which came up recently while observing that mere inconvenience faced by the accused to appear for trial cannot be the ground to transfer proceedings under section 406, that is power of Supreme Court to transfer cases and appeals to the Criminal Procedure Code, and section 447 of Bharatiya Nagarik Suraksha Sanhita. The Supreme Court stated that an order of the transfer of the trial cannot be passed as a matter of routine. And I read the exact paragraph of observation provided by the Supreme Court. I quote, "Thus, although no rigid and inflexible rule or test could be laid down to decide whether or not the power under section 406 of the CrPC should be exercised, yet it is manifest from a bare reading of subsection 2 and subsection 3 of the said section, and on an analysis of the decision of this court, that an order of transfer of trial is not to be passed as a matter of routine, and more particularly on the plea of lack of territorial jurisdiction of the court to try the offence under section 138 of the NI Act, that is Negotiable Instruments Act 1881, this power has to be exercised cautiously and in exceptional situation where it becomes necessary to do so to provide credibility to the trial. My dear friends, while observing about section 406 of Criminal Procedure Code 1973 vis-a-vis section 447 of Bharatiya Nagarik Suraksha Sanhita, it was the Supreme Court has come out with 5 important points. These 5 important points are very, very important with respect to section 406 of the Criminal Procedure Code 1973 and section 447 of Bharatiya Nagarik Suraksha Sanhita, and accordingly these 5 points are important. The Supreme Court has said, while holding that this was not a fit case for the transfer of trial in the expedient to the justice, that is 406 of the CrPC, the court specified 5 broad instances where the trial could be transferred. The 5 broad instances are: the first one, when it appears that the state machinery or prosecution is acting hand in glove with the accused. Only when the state machinery is acting in hand in glove with the accused and there is a likelihood of miscarriage of justice to the lackluster attitude to the prosecution. 2, when there is a material to show that the accused may influence the prosecution witnesses or cause physical harm to the complainant. The third observation based on which the cases can be transferred: comparative inconvenience and hardship likely to be caused to the accused, the complainant or the prosecution and the witness, besides the burden to be borne by the state exchequer in making payment of travelling and other expenses of the official and non-official witnesses. Fourth important point that the Supreme Court has observed with respect to section 406 of the CrPC and section 447 of Bharatiya Nagarik Suraksha Sanhita, a communally surcharged atmosphere indicating some proof of inability to hold a fair and impartial trial because of the accusations made and the nature of the crime committed by the accused. And the fifth important point of observation is that existence of some material from which it can be inferred that some persons are so hostile that they are interfering or likely to interfere either directly or indirectly with the courts of justice, then in all these cases transferred from one state to another state. Except for these instances, the cases cannot be transferred to another state, my dear friends. My dear friends, this is a landmark judgment with respect to section 406 of the CrPC vis-a-vis section 447 of Bharatiya Nagarik Suraksha Sanhita. I am very sure all the law students should update yourself with the Supreme Court judgment, because you may know the plain provision or the bare provisions of section 406 and 447. But the recent Supreme Court adds a flair and provides a clarification and declares the law as it stands today. Thank you.